We've got Major League Baseball, of course, right here on Sirius XM, and you got to go looking for that. Just check the channel listing. Trucking is what we talk about during the next 2 hours here on the program. And coming up during the first hour here on the program, drivers, I got a brand new voice I'm going to be introducing you to on the program, an attorney by the name of Wesley Ball. Now, you probably heard about a story about the jury in Houston finding Swift liable in a lawsuit brought by an owner-operator leased to the company who claimed negligent maintenance practices. So we'll get into that coming up in a minute. First, though, top news stories right now on Sirius XM. That's the news, and again, it's 888-876-2336 all across North America. You probably have heard about or read about this story. The jury in Houston federal court finding Swift liable in a lawsuit brought by an owner-operator leased to the company who claimed negligent maintenance practices by Swift caused a trailer to run over his foot. And I've got attorney Wes Ball on the phone with me now. And, sir, I want to welcome you to the show. Good afternoon to you.
Hi, Mark. How you doing? Thanks for having me on today.
Yes, sir. I appreciate it. Set this up for the drivers now. You're live across North America. A little background about what you do so we can set the table for the guys listening.
Sure. I'm an attorney out of Houston, Texas, and I focus mainly on plaintiff's work. And I guess another way of saying that is I file the lawsuits rather than defend them. I focus mainly on victims' rights and specialization with trucking injuries. I represent both truck drivers and injuries that are occurred to other people other than the truck drivers themselves. And then in addition to that, my law firm focuses quite a bit on product liability cases with an emphasis on tire failures, tires that would fail and then cause an accident thereafter. So we have quite a large array of stuff that we do, but it's generally focused on the individual that's injured.
Okay, and from what I'm reading here, that you've represented major automobile, tire manufacturers, domestic and foreign manufacturers, as well as numerous Fortune 500 companies. So you've got a lot of background in this, right?
I do. I actually have. I've represented the gambit of people when it comes to determining who was at fault for the negligence of the failure of a product.
Okay, outstanding. So thanks for setting that up for us. And that's, with new guests on the program, I have them give a little bit of background about their expertise and things like that. Now, this story involving Swift has been in the press for about a couple of weeks, and I'm glad you're here to break the story down point by point. Now, set this up. Who is Herbert Willoughby?
Sure.
Who is this gentleman?
Herbert Willoughby is a gentleman that I come to represent almost 3 years ago, and Herbert resides in Virginia and has been an owner-operator for Swift for almost 20 years, a little less than 20 years. And the way the Swift runs their company is they request their senior drivers to mentor the new drivers that have already been trained and received their CDL. And the way that this really set up was that Herbert was on, I think, at this time, his 109th mentee. Everything had been well with him, with no other prior incidences. And lo and behold, he picked up a trailer that ultimately failed, and the tandems on the trailer ultimately failed and caused some pretty severe injuries to his foot. And I can go into as much detail about any of that as you'd like, but that's kind of the general setup of it.
All right, outstanding. Yeah, and we're going to get into a lot of the nuts and bolts with this. And I'm reading from some of the trucking press out there that though the owner-operator was partly to blame, the jury found Swift was most at fault in this 2012 accident in which Willoughby, according to some of your statements, adjusting a tandem unit attached to a trailer when it ran over his foot. Now, obviously, there's probably been a lot of discussion about some of the procedures that were followed or not followed. I think one of the most important things to get out there at this point was Mr. Herbert Willoughby's foot ever in the path of that tire. Explain how that works, if you will.
Sure. Yeah, and I can tell you this. There's obviously two sides of that coin, two stories there. Swift's story and our story. Our story was that at no point ever was Herbert's foot in the path of that tire placed there voluntarily until the tandem malfunction, reconnecting the pins to the trailer itself, and then the trailer lunging forward, which caused him to move forward just a little bit and then place his foot within the path of the tire. As I say, there's two stories there. You know, what really was upsetting, I think, to Herbert and ultimately to the jury on this case is, you know, it really started off with just one story. There was one story from Herbert, and there was one story from Jason Cribbs and Swift. Jason Cribbs was the Swift employee, the mentee that Herbert was mentoring. And I say that because after the incident, it happened at Home Depot Distribution Center in Houston first. I'll set it up that way. And then after this incident occurred, within about an hour or so, Home Depot requested that Jason Cribbs fill out what is termed an incident witness statement. That's what it's called at the top of it. Jason Cribbs wrote out in his own handwriting and signed it, stating what he understood had happened and what he had seen happen. And what he said happened is the exact same thing that Herbert said had always happened. And also, probably about 6 months later, Swift, through their own internal investigation, found that everything that Jason had placed in his statement and what had gone wrong was the exact same way that Herbert said it happened. So the short end of that is you know, there was one story, and then unfortunately when we got to trial, Swift and the story that developed on their behalf inside the courtroom was quite different. Jason Cribbs withdrew his statement. Swift said that their findings were incorrect, and you know, I think that's really what led Herbert to ultimately pursue this all the way to the courthouse, and what I think upset the jury ultimately as well, because we had one story and then it changed not only to two stories, but at one point they had given 3 or 4 different stories.
And based on that, I mean, when you found 3 or 4 different stories or in the process of being worked through, did that come up through the process of discovery? Did that come up during the course of the actual trial itself? How did that come to light, in other words?
Yeah, sure. It came up through discovery. It came up through a lot of hard work that we had during, you know, I think in the case we wound up taking somewhere around 20 or 30 depositions, and the testimony that came out, the witness statements that came out, and then ultimately some pictures and inspection of the trailer itself really revealed the same story that Herbert had always said, and revealed a different story than what the story on the inside of the courtroom was. For instance, Mr. Cribbs had given an incident witness statement. In that witness statement, he used the pronoun I. I pulled the truck. I did this. He used that, I think, about 11 different times, but then said, nope, none of that was mine. And it really came down to what was the maintenance condition of this truck, and throughout the discovery during the case, we found that the tandems themselves on this truck, the repair records, the tandems had needed to be repaired six times previous to this incident, and as a matter of fact, the tandem and the sliding tandem mechanism itself had to be repaired about a month after this incident occurred. And, go ahead.
I was going to say, and based on the amount of requests that went in to try to get the trailer properly maintained, or the maintenance applied to it there, was that a time-consuming task to gather all of that? In other words, did it kind of add to the to your client's case about repeated attempts to try to get that equipment fixed?
Oh goodness, yes. I mean, it was about a 3-year process in order to, ultimately gather all of the facts that were used at trial, because as you would probably imagine, Swift didn't just voluntarily open up their books and provide us with everything we asked for to begin with. As a matter of fact, when the lawsuit was filed, it was about a year and a half after the incident had happened, and then, at that time, Swift said, by the way, we no longer have the trailer. Lo and behold, about 2.5 years after the lawsuit was filed, and about 5 or 6 months before the case went to trial, Swift ultimately found the trailer. And that trailer, we didn't realize it at the time, but that trailer during the inspection produced some pictures that became very, very relevant and some turning points during the trial itself, because we found some repairs that were performed to the tandem lever handle itself that became very relevant, and I think that the jury obviously clued in on and became very relevant to them.
And based on that, when that item became relevant to the jury, did that kind of turn the tide, so to speak, and then this maybe wound up in a favorable decision for your client?
Oh, I think it did. I mean, you know, the entire time, really, and if I can, I'll give you a little bit of background as to why it was relevant. You know, Herbert picked the trailer up with the mentee, Mr. Cribbs, on June the 5th in town right outside of Greer, South Carolina. When he picked it up, it was fully loaded, and it was to be delivered to the Home Depot distribution center in Houston. When he picked it up, he and Jason both realized that there was something wrong with the tandems, and essentially what was wrong when they went to slide the tandems to comply with the bridge laws before starting on their trip, they realized that the tandem handle itself, when it was locked in place into the notch, wasn't pulled out far enough so that the pins would disengage from the rails, so the tandems would not slide, allowing for the movement of the weight of the trailer. So Herbert called his supervisor. Again, none of these facts are disputed. Everyone agreed with it. Herbert called his supervisor and said, "Listen, I got a problem with the tandems. They won't slide properly. I can't make it as a one-man operation. It has to be a two." And they said, "That's fine. Take it to Greer, South Carolina," which was their closest main large repair facility. So he did that, and about 3.5, 4 hours later, the trailer was handed back to Herbert, and the repair technician said, "Listen, you know, we can't fix the tandems the way that they need to be fixed because it's fully loaded, and we would need to unload it, which we can't do because this is not the destination for the drop-off. So what you're going to need to do is turn the tandem shifting into a two-man job, essentially. One person in the trailer while the other person holds the tandem handle." And what Herbert needed to do was pull the tandem handle beyond the notch that was made in the tandem handle, so that when the trailer then moved forward, the tandems would shift. I think as all veteran and even new truckers understand, when you're back there behind that wheel pulling that tandem handle, you're pretty darn close to the wheels. And it's not, I know it's done on a daily basis, but it's still not the safest thing to do. Everyone would like for shifting of the tandems to be a one-man job. That's the safest way.
Sure.
So the repair technician said, "Don't worry, everything will be fine with it. It'll be safe. It'll just be a two-man operation." So what happened is he then went to the Home Depot distribution center. He pulled in, and the distribution center in Houston has about a quarter of a mile long, two-lane private driveway. And there's no notice of what needs to happen before you get there. When he pulls up to the guard shack says, "You need to shift your tandems before coming in." Herbert looks at him and says, "Well, I'd like to do that, but they're broken. I can't." And I think, as all truckers have probably seen at one point in their career, the guards there said, "I don't really care what your problems are. My problems are that I'm told you have to shift them, and if you don't shift them, you can't come in."
Right.
Backing out a quarter-mile-long driveway after that wasn't really an option, so Herbert had no choice at that point other than to just sit there or to perform the two-man operation. So he tried to perform the two-man operation, and really what happened was Jason, his mentee driver, got in the cabin. Herbert went to the back, pulled the tandem handle, and had to hold it past that notch. While he held it past that notch, Jason started to move forward, and as he started to move forward, those tandem pins failed and reconnected with the rails. And when they did that, Jason did not let off of the gas, and really he was using gas and the clutch at the same time. And when he did that, it caused the tires to skip, which caused Herbert to be pulled off balance and him take a step in front of the car or in front of the wheel and simultaneously run over his foot. And the reason I tell you all that stuff is because during trial we had a picture produced to us of this trailer 2.5 years after the lawsuit was filed, which would have been about 3.5 years after the incident occurred. And a picture of that trailer showed that tandem handle now having 2 notches in it, not just 1 notch. And I think, as everyone knows, the original manufacturer never puts 2 notches in a tandem handle. And it just happened to be that second notch was the exact amount, a difference between the first notch and the second one, that tandem handle needed to be pulled out in order to disengage those pins. And we hadn't seen that before, and Swift had claimed that because the repair records were silent as to fixing the tandem handle itself after this incident, that proved there was nothing wrong with the tandem handle, even though everyone agreed something was wrong with it the day before. And then that picture proved, well, you didn't put that into your repair records, so something fishy's going on here, and I think the jury picked up on that very quickly.
And when we come back out of the break, are you going to specifically say collusion with this? We're going to get into more of the conversation coming up in just a minute. Drivers, again, if you want to jump in, you're more than welcome if you got a question. For attorney Wesley Ball, he is the attorney representing Herbert Willoughby, and a jury in Houston-based federal court finding Swift liable in a lawsuit brought by an owner-operator leased to the company who claimed negligent maintenance practices by Swift caused a trailer to run over his foot. So that's according to some of the trucking press out there. And again, if you want to jump in, you're more than welcome to do that. Drivers, 20 minutes after, it is...
You're listening to Road Dog Trucking News with Mark Willis.
Drivers, you probably have heard about or have read about this story. Basically, if you're just now joining me, a jury in Houston federal court finding Swift liable in a lawsuit brought by an owner-operator leased to the company who claimed negligent maintenance practices by Swift caused a trailer to run over his foot. Now, the jury has awarded the owner-operator Herbert Willoughby $2.6 million for physical and mental pain, medical expenses, and past and future lost wages. I have reached out to Swift to try to get a comment on this story. They've not responded as of yet, but once they do, I'll certainly get that on the air. Now, attorney Wesley Ball is with me right now. Sir, I appreciate you doing this, and we've got a number of folks that are holding on the line with us. And, based on what you've been discussing here on the program, setting up some of the facts associated with this, what is your thoughts concerning possible collusion in connection with this case? Any basis in that? Was that part of the jury's consideration when they were looking at the verdict?
Well, to be honest with you, I don't know what the jury really focused in on specifically. Obviously, we're not allowed to listen to their deliberations, and I've found that juries can latch on to some of the smallest facts all the way to the largest ones.
Sure.
So putting yourself in those shoes is something I'm just, above my pay grade. But, that being said, to take the high road here, so to say, before this lawsuit ever made it to a courtroom or to trial, Swift had been sanctioned based upon our motions on 2 different occasions for conduct and discovery that was really unbecoming of the justice system, and the judge saw that and made sure to straighten it out one way or the other. The way that I've always seen it is anytime there is a large company and money at risk, people do things that maybe they wouldn't otherwise. I'm not to say here that Swift did that. It's part of the world we live in. But fortunately, if you're diligent and follow up on the facts and make sure to have a handle on all of the facts, then at the time of trial, as we did, we're able to show a jury what happened, and a jury of Herbert's peers agreed with his story.
Yeah, and in some of the trucking press reports I've been reading, like CCJ Digital, for example, there is a mention that the owner-operator was partly to blame. Is that true? And if so, how is that true?
Well, the jury found that the owner-operator, Herbert, was 43% out of 100% total to blame for this. Now, the reason for that, again, I really couldn't tell you exactly what the jury thought was, but from deduction and seeing everything at trial, and from judging the jurors that were put on the panel itself, I would think that it's probably because they believed that Herbert knew that there was something wrong with the trailer itself, and he was given an option. Well, there was testimony that he was given an option to reject that load, and he didn't reject that load. Now, I think they also understood, because they didn't place a majority of fault on him, that rejecting that load isn't just as black and white as someone would like someone would like to see. You reject a load. There was very good testimony on it that Swift did what other truckers call put you in the penalty box. Herbert no longer gets the loads that he would have otherwise gotten, and he's really faced with a pretty major dilemma there. And I think the jury picked up on that and understood that it was a dilemma that's not just cut and dry. And it was for that reason why Swift was more to blame for placing him in that dangerous position. Or really, the way that I look at it is they didn't provide him with a good workplace. Okay,
and based on that, I mean, providing a good workplace, and let's get into this when we come back out of the break. Providing that good workplace, does that mean giving drivers certain written procedures and protocols that have got to be followed? And let's get into that. I got a break here because I'm coming up on some housekeeping stuff, but hold that thought for just a minute. Drivers, again, if you want to jump in, you're more than welcome to. I've got attorney Wesley Ball with me on the phone, and a very interesting story. It's been making rounds in the trucking press involving a jury in Houston finding Swift liable in a lawsuit brought by an owner-operator leased to the company. And I have reached out to Swift to try to get a reaction, but nothing as of yet. Once I do, though, I'll certainly get it on the air. Bottom of the hour, That Means News right now here on Sirius XM.
And now the latest from the Road Dog Trucking Radio News Team on Sirius XM.
All right, drivers, some of the top stories we are indeed following for you this hour right here on Sirius XM's Road Dog Trucking News. The Centers for Digital Government announcing that the Department of Transportation, FMCSA, won a Digital Government Achievement Award for the Pre-Employment Screening Program. FMCSA, according to this release, is the only winner in the Driving Digital Government federal category. Now, the award recognizes outstanding agency and department websites and projects at the application and infrastructure level for all levels of government. And launched in 2010 to improve highway safety, the PSP provides trucking and bus companies secure and instant access to commercial drivers' safety history records for pre-screening hiring purposes. Drivers, TTNews.com reporting with the Congress now coming back in new session. There's going to be a lot of talk on the Hill about the transportation infrastructure. Transportation Secretary Anthony Fox, Teamsters President James Hoffa, and former Mississippi Governor Haley Barbour are scheduled to talk about infrastructure at the National Press Club. The ranking Democrat on the Senate's transportation panel said recently that it is, quote, ridiculous that the Congress is yet to advance a long-term highway bill. And also, if you want to learn more about why you are stuck in traffic all of the time, then you might want to pick up a copy of the 2015 Urban Mobility Scorecard that was released last month by the Texas A&M Transportation Institute. And one other note, the U.S. Environmental Protection Agency and the National Highway Traffic Safety Administration has extended through October the 1st a comment period for an expansive proposed rule on greenhouse gas for trucks. Drivers, that's the news. Again, it's 888-876-2336. All right, don't go anyplace, guys. Great conversation going on with attorney Wesley Ball. Back in a few minutes. I'm Mark Willis, live across North America right here on the Sirius XM Road Dog Trucking Channel.
The Dave Nemo Show on Road Dog Trucking Radio.
Tim Ridley is about ready to head for the woods. Good morning, Tim.
Hey, good morning, Dave. Are you a regimented traveler?
I was one of those guys who would say, well, I don't know where we are, but we're making good time, you know. Yeah, we made that in 17 hours and 9 minutes. Beats last year's 17 hours and 12 minutes.
The Dave Nemo Show, weekday, 7 a.m. East, only on Sirius XM's Road Dog Trucking Radio.
Schneider has led the trucking industry for 80 years. That's 80 years of outstanding truck driving careers. You can't lead an industry without reinvesting in your business. From CSA concerns to lost earnings caused by maintenance downtime, the equipment you drive impacts your livelihood. Schneider's fleet is one of the newest and includes features that prioritize driver safety, including anti-collision and roll stability systems. Visit SchneiderJobs.com to see for yourself why Schneider leads the trucking industry. That's SchneiderJobs.com.
As if saving time, fuel, and money wasn't enough, drivers who use PrePass for way station bypassing and electronic toll payments can now pay their bill over the phone using a credit card or checking account number. Pay anytime, anyplace, 24/7, 365 at no additional charge. Just not when you're driving, of course. What can PrePass do for you? Call 800-773-7277 to find out. Get the most out of every minute on the road with PrePass.
Life after military service is different. Many veterans find transitioning difficult, feeling lost and uncertain about the future. These feelings don't take away from a veteran's strength, courage, or sense of duty. If you're a veteran in crisis or know one who is, the power of one person, one connection, one act of compassion can make a difference. For free 24/7 confidential support, call the Veterans Crisis Line at 1-800-273-8255 and press 1 or visit veteranscrisisline.net.
Fuel up, hook loads, hammer down, and watch those yardsticks fly by. Yeah, you're a trucker, and if your wheels ain't turning, you ain't earning. We know you wear a lot of hats, and you don't have time for downtime. At Dayton, we appreciate how hard you work. That's why we provide affordable tires, made to keep you moving day in and day out. To find a dealer near you, visit DaytonTruckTires.com. Dayton, tires for truckers.
Lots of rain across northeast Wisconsin, working on into parts of Michigan at this time. We've had 1 and 2 inch rainfall amounts and some flooding reports. All the action, though, is staying well to the north of any of the major interstates across Wisconsin and Minnesota at this time. The only interstate really seeing any impacts is along I-75, but you got to get well north of Saginaw to start to see some of that shower and thunderstorm activity. Storms stretch on down into parts of Illinois, where we are getting quite a few reports of lightning in some of those thunderstorms around the Rockford, Illinois area, watching showers and thunderstorms. Travelers along I-80 from Chicago on over toward the Quad Cities be on the watch for rain showers and thunderstorms. Also have some showers and thunderstorms across central Missouri. Showers and thunderstorms just west of Columbia along parts of I-70 and I-44. Travelers around Springfield and Joplin, watch out for rain showers and storms. Richard Wedding with custom weather for drivers twice an hour on the Road Dog, Sirius XM 146, and on the Sirius XM app for smartphones.
Back to Road Dog Trucking News with Mark Willis.
Drivers, a brand new voice here on the program. It's great to be speaking with attorney Wesley Ball. And, sir, thanks for doing this. I really appreciate you breaking down the specifics of this story that is appearing in a lot of trucking press, and some of the mainstream press has picked this up as well. And, again, drivers, I have reached out to Swift to try to get a comment on this. They've not responded as of yet. But once they do, I'll certainly get a statement up on social media and certainly get that out on the air. Wes, where can drivers maybe read about the judgment, the decision on the part of the federal court jury? Can they go to your website? Is there a social media spot where they can read up on this? What would you say?
Sure. My website certainly has information up about it. There'll be more information up about it by the end of today. My website is www.fbtrial.com. That's F as in Frank, B as in boy, trial.com. And then, as you had adequately mentioned, there's quite a few national media outlets that have picked up on the story as well. Google searches with Swift and Houston verdict kind of does the trick as well.
I appreciate it, sir, and thanks for doing this because at the end of the segment, there's a much bigger story here that we want to get out as well to the drivers, and that is that penalty box that you mentioned. But one of the questions I had prior to going into the break was any kind of written statements or protocol that the driver needs to follow when performing these type of procedures. Are these procedures specifically in writing? In other words, did it come out during the trial that maybe Swift provided documentation as to how these procedures needed to be handled?
Well, There was documentation concerning how the procedure of shifting a tandem as a two-man job should be handled and as a one-man job, and really no one disagreed on any of those procedures. Swift has taken and did take the position that Herbert just put his foot in front of the tire, and the procedures that Swift had concerning shifting of tandems essentially had a nonsensical thought of them of, don't put your foot in front of the tire, and we all agree with that. Herbert has been adamant the entire time that his foot was never at any point in front of the tire until the tandems failed, and again, that was the witness statement that was written, and that was Swift's internal finding as well. As for the procedures concerning the rejecting and accepting of a load, there was testimony that that Herbert could at any time reject a load if he felt it was unsafe, but there was never anything placed in front of a jury saying that was the case, and there was never any policies that we found that was the case. Now, common sense would think that you can, obviously. I mean, you know, your foot doesn't have to press that gas, so you can reject it, but that's when it really comes into the risk versus reward and the problems that I think truckers see on a daily basis with doing that. You know, I would never pass judgment on someone one way or the other, whether they do accept it or they don't accept it. That's their own personal consequence, because, you know, it's not my family that they've got home having to feed, and if they reject the load and they believe the company is going to penalize them for that, and it really comes down to an issue of, well, do you think that it's so unsafe that you can't take that risk, or should you take that risk because if you don't, there's going to be no other way to make that money? That's really a decision up for the truck drivers, and again, I think the jury saw that as well and understood that to be an issue rather than just a black and white issue.
All right, now was Home Depot part of this settlement, or were they withdrawn from this?
They were not. Before trial, Home Depot was not. Home Depot was taken out of the case. Let's put it that way. They were not part of the jury settlement, or part of the jury.
All right. Now, what about as far as Mr. Cribbs was concerned? Is he still part of that, or was he removed?
No, Mr. Cribbs was part of the lawsuit as well. You know, in the law we have something called respondeat superior, and that is just essentially that an employee makes the employer responsible for the employee's actions. So, as sort of a procedural thing, we needed to add Mr. Cribbs into the lawsuit. Now, the jury found that Mr. Cribbs had 8% liability in this, 43% on Herbert, and then the remainder of it on Swift.
Okay, now, and based on that, would Mr. Cribbs be responsible for any monetary damages in connection with this?
He will not. Mr. Cribbs was an employee, full employee, not an owner-operator, but a full employee of Swift. Okay. You know, that's something that you can't tell the jury about, and the jury wasn't told about before they rendered their verdict, but the short end of that is that Swift picks up the tab for Mr. Cribbs.
All right, let's go to the phones. Harper, you are going to be first up. You're a good soul. Thanks for waiting during the commercials. You're on with Attorney Wesley Ball. Go ahead.
I'm just curious as to how this got to court at all. This is a very standard problem with this style of trailer, and there is a very standard procedure for dealing with it, which obviously the owner-operator didn't follow, and that is you pull the handle out till the pins are pulled in, and you put a vice grip on it and stand back. He should have never been there in the first place.
What would you say to that, Wes? You know, how did this really wind up in court in the first place? How would you respond to Harper?
Well, I think the first way I'll respond to that is, Ms. Harper, you're correct in that there are alternative ways that you can rig this up to hopefully step away from the trailer itself. Mr. Willoughby, Herbert, as I've been calling him, gave this truck to the repair facility, and the repair facility gave it back to him and said that it's safe for him to hold it out. That was his instructions. Hold on to it, hold it out. There was testimony and evidence during the trial that, yes, you could rig this tandem handle up with a vice grip, or even take your belt off and pull it and stand further away. The problem with that is that That is rigging this up in a manner that places someone in harm's way. Now, does harm always occur? No, it doesn't. But this was more of an issue of setting a precedent. I think truck drivers on a daily basis are faced with unsafe conditions, and you have to deal with those conditions. But this was an instance where the condition came up, the truck driver made the company very aware of it, and the company essentially ignored it thereafter. And it's not in documentation, it's not an accepted procedure to use vice grips or belts or whatnot. And what we're focusing on here is making sure that the workplace is safe from the beginning, not rigging it up halfway through to try to make it safe at that very moment. Trucking companies have plenty of time and money to make their trailers safe, and that's something that they should do rather than placing the onus on the driver themselves.
Harper, I appreciate you. Are you still there?
Yes, I'm still here.
Okay. All right. Do you have another comment? Okay, I think we lost her. All right, I appreciate it, Harper. You were starting to break up, but let's keep going. Let's go to Greg in Virginia. Greg, thanks for waiting. You've also got some similar thoughts about the vice grips, right?
Yes, I do. Vice grips are really good. The other thing is, does Swift have a paper inspection report where the driver could fill it out as non-functioning slider handle and therefore make the mechanic sign this that says, well, it's okay, therefore I'm not liable?
Well, they kind of do, and the way that is, and the reason I say that kind of is because that was never produced to us. The testimony and the facts were agreed.
The driver did not maintain his copy of said report.
Well, and that's what I was getting to. The driver actually never gets a copy of it. What the driver does is he takes it to the repair facility, he goes to the front desk, he fills out a little piece of paper of what's wrong with it, he hands that piece of paper in, and it puts the truck into a rotation to be fixed. After that happens, then the driver takes the truck, or more repairs need to be done as needed. The technician who repaired this trailer, lo and behold, at the time of filing of this lawsuit, Swift said they couldn't find him. So when it comes to maintaining paperwork on Herbert's behalf, that's not a procedure that Swift has in place. They might have it in place now, but they certainly didn't have it in place then. That being said, there were repair records and adequate documentation of the repairs that were needed to this truck and this tandem the day before the incident, and also for at least 4 times on 4 separate occasions before the day of the day before the incident. So it was very well documented that this trailer and the tandem specifically had needed to be repaired on multiple occasions. And as drivers know, you're not provided when you pick up a trailer and take it from point A to point B. You're not provided with a history of the maintenance on that trailer. That's not something that Herbert ever saw. That's something that I found after the lawsuit was filed, and I requested documents be provided to me.
Yes, and a good pre-trip is a valuable lesson, and so is extra paperwork dealing with giant companies that say, oh, we lost that piece of paper. No, I've got a copy of it.
Greg, I appreciate the phone call, and let me ask you this, Wes. Do you think this is going to be a wake-up call for a lot of other companies out there to maybe streamline some of their maintenance procedures when these kind of items do come up?
Boy, I sure hope so. I really do. You know, the first thing that the jury was made aware of in this case is that I think everyone agrees that all employees deserve a safe workplace. I don't think anyone would disagree with that. And the follow-up to that is that a truck driver's workplace is his truck and his trailer. It's not his office. It's not his factory. It's not the assembly line that most people think about on a general basis. And I believe that all truckers need and should be provided with a safe workplace, especially from these large companies that have the resources, expenses, and time to maintain their trailers in a manner that provides that safe workplace. And I'm really hoping that Swift, particularly because it's such a large company, and other companies, large and small, will streamline their repair process, and rather than placing Band-Aids on it, fix it a lot better.
And did the size of the company come into consideration, like you're mentioning, when it came to determining the jury award in this case? In other words, if the company had been much smaller, would the jury damages also would have been maybe much smaller? What would you say?
Absolutely not. And the reason I say that is because us lawyers are never allowed to talk about how large a company is, the assets that the company has, things like that.
Okay, so that would not have come up during any course or any period during the trial.
You know, it never comes up from the lawyers. The judges give us specific instructions that we can't do that. We're not allowed to motivate a jury that way, one way or the other. Now, obviously, common sense comes into play.
Sure.
If the jury's heard about them, but the judge instructs the jury to do absolutely no research during the pendency of the case, and we are instructed as lawyers, as a regular instruction in all trials, that we are to in no way motivate a jury based upon the size or assets of a company.
All right, I got to break one more time. Downhill in Louisiana, got you coming up. He wants to know, Wes, and we'll discuss this out of the break. Why was he hauling it in the first place if he is talking about the bridge law? So drivers, hold on. Lots more coming up for you. For the meantime, though, let's wrap up the conversation with attorney Wes Ball. And, sir, thank you, man, for really doing this. I appreciate you, talking to the drivers and, clearing up some of the facts involving the case out there. Let's go to the phones. I got one more caller I want to try to get on. Let's go to Downhill in Louisiana. Welcome to the show, sir. I appreciate you joining me. You're on with attorney Wesley Ball. Hello, Downhill.
Hello.
Hello. Welcome to the program, man. You're on the air. How are you?
Okay. Hey, I got a question. You said at the beginning that he couldn't slide the tandems because of the bridge laws, but he took it to the shop to get it fixed. If he couldn't slide the tandems because of the bridge law, why was he even taking the trailer in the first place?
Sure. Let me clear up a little misconception there. When he picked the trailer up, the tandems were fully slid forward, so he needed to slide the tandems rearward to comply with those bridge laws. And when he did that is when they realized something was wrong with the tandems. They performed that two-man procedure successfully before the trip began, but it was still broken. So they took it to Swift, and then that's when Swift welded the tandems, did some other work to the tandems. Well, when the truck was provided or given back to Herbert, those tandems were already slid rearward so that any trip across interstate highways, bridge laws were complied with. Mm-hmm. When Herbert then got to Home Depot is when Home Depot said, as our own internal policy, you need to slide your tandems the way that they wanted them slid, and that's when Herbert needed to slide his tandems again. And so the second time, which happened to be after those tandems were worked on by the Swift personnel and welded, that's when those tandems failed.
And to this point, Wes, where does this go from here? I would imagine, of course, that Mr. Willoughby's not able to work anymore. Is this going to be a case where this is going to be appealed? Is this going to go maybe to the circuit courts? Where does this go from this point forward?
A lot of that really just depends on Swift. Swift's attorney began the case by saying they'd respect the verdict, so we're going to find out sometime in the next 30 days if they do. I don't understand how they would appeal it, but, lawyers do what lawyers do, and maybe they'll appeal it, maybe they won't. As it concerns Mr. Willoughby, you're correct. He'll never work again. The trailer that ran, it didn't run over his entire foot in terms of his ankle and everything, but it ran over about 2/3 of his foot, and when that happened, his foot virtually exploded. I mean, there's no better way to say it other than it just popped like a balloon. And he has since had to have pain stimulators or neurostimulators installed in his back. He's right now walking with a cane. That's probably pretty soon going to go to a walker and then to a wheelchair. I mean, the nerve damage that resulted from this injury is something that I certainly never want to feel, and I don't think anyone else does. It's not just a small foot problem that he had here. He really only has one good foot now, and the other foot he really wishes he didn't have.
Now, and if this does go to appeal, confident of the victory, or do you think maybe something might come in out of the blue that might change another jury's mind with this?
No, I could never see that happening. You know, there's always issues anytime we try cases that people can try to exploit one way or the other, regardless of what side you're on. I'll be the first to admit, but
sure.
You know, this one's pretty straightforward. It's pretty clear. The documents said what they did, and the jury came to the decision that it did. And I just don't see any room for that. But like I said, lawyers do what lawyers do, and who knows? We'll find out in the next 30 days.
All right, keep me posted. Maybe do a follow-up with you, indeed, if this does get appealed. And drivers, again, I have reached out to SWIP to try to get a reaction to this story. Nothing yet, but once they do, I'm certainly going to post it on social media and also have it on the air to present both sides. Wesley, thank you, sir. I appreciate it. Using me, and so I got to wrap it up. I thank you for the time. Thanks for explaining the story. Have a great day.
Thanks for having me on, Mark.
All right, outstanding. Drivers, that is attorney Wesley Ball on the program, and this story is pretty much all over trucking media if you want to read a copy of it, but it is very interesting when you look at some of the maintenance protocols that are out there when it comes to, inspecting the equipment, making sure it's in operating condition. Who's ultimately responsible for this? If the mechanic at your shop is signing off on it, and indeed if the equipment is not working properly, ultimately it's going to fall on you to make sure that the equipment is in compliance when you fill out your logs. So again, if you want to research it, I'll put more information up on my Facebook site, Sirius XM's Road Dog Trucking News. Back in a minute right here, Sirius XM 146.